Welcome back to the Sutliff and Stout Legal Podcast. I'm Abby, and today I'm here with Hank Stout from Sutliff and Stout Injury and Accident Law Firm. Good to have you back, Hank. Thanks for being here.
Good to be here.
So today we are tackling the full cycle of a car accident lawsuit in Harris County, from the moment a crash happens and investigators start determining who is at fault, all the way through settlement negotiations, the statute of limitations, and what happens if the case goes to trial at the Harris County District Court. Harris County leads Texas in total crash volume, and the Houston Metro sees a disproportionate share of serious accidents along corridors like 45, I-10, 610, US 59, and Beltway 8. Most people who are in a crash have no idea how fault determination, insurance settlement negotiations, or civil litigation actually work under Texas modified comparative negligence system with its 51% bar. So getting into question one, a crash happens on 45 or at an intersection along Westheimer Road, and the question everyone wants answered is whose fault it was. So when a car accident happens in Houston, how do investigators begin determining who is actually at fault?
That's a great question, Abby. And so in every car accident that you get involved in, if the police show up, they'll question the occupants of the vehicle to see what happened. If any witnesses stay around, then they'll question them. They'll see if there's any dash cam video or other things. They'll look at the physical evidence, where the cars are located, where the lane markers are, and then make a determination, at least in their mind, who is the contributing factor to the collision, because that's what the police determine as contributing factors. And then as a lawyer, I'll use that information to look at it and say, okay, this is who I think is responsible. And the insurance companies do the same thing. They look at pictures, they listen to what people say on body cam footage to try to determine, well, who did what and why did it happen.
And the Houston Police Department report, or the Texas DPS report, if it happened on a highway, is usually the first official document in any accident case. What role do police accident reports play in determining fault after a crash in Harris County?
Sure, that's a great question, Abby. The police report is a great starting point. It's not the end-all be-all because a lot of officers, they didn't witness the collision, so technically they may or may not be qualified to testify. But it's a great starting point for both lawyers and insurance companies to get some basic information about the who, what, where, when, what insurance companies are involved, who was coming from where, contact information for individuals who were involved. And so that's a great starting point for everybody to kind of look at and try to figure out, okay, what happened in this instance?
And then the police report is just one piece, but the insurance company is running its own investigation at the same time. So how do insurance companies conduct their own investigations to determine fault?
Great question, Abby. And so when I say that the police report is a great starting point, but it's not the end all be all. Just as a lawyer for an injured person, I don't have to accept the results of the police report. Neither does the insurance company. And so the insurance company will look at the report and see if they agree with it. If they agree with it, then obviously they'll use it to support their position. But let's say it holds their insured at fault, then the insurance company will look for reasons why their insured wasn't at fault, or why fault should be shared by the other person. Because in Texas, the law looks at the actions of both parties and then ask the jury to assign fault based on, the actions of each individual in the collision.
Then beyond the reports and the statements, there is physical evidence at the scene that tells its own story. So what kinds of physical evidence from the accident scene can help establish fault?
It's a great question, Abby. And so when I look at property damage photos, I'm looking for not only the crush damage, how significant was the impact, but I'm also looking at angles, where the damage occurred, how the damage occurred, where the vehicles were positioned on the roadway. Those are all things that are very helpful to me to try to determine who did what, because oftentimes people, whether intentionally or not, they may not exactly remember what happened, or they may think it happened in a way that it didn't actually happen. And so the physical evidence on the vehicles and the pictures of the damage to the vehicles is very helpful in that regard. Same thing with like the way vehicles are, right? Is there a turning lane? Is there not a turning lane? Is there a, is there a second Is there an additional lane of travel that somebody thought was there but really was a turning lane? I mean, there's a whole bunch of things that the physical evidence can tell you about a collision that helps you determine who's at fault for the collision.
If one driver ran a red light or was speeding, there is a legal concept called negligence per se that makes Texas Transportation Code violations especially powerful in court. So, how do traffic violations like speeding or running a red light affect liability in accident cases?
Sure. So negligence per se is a concept that lawyers use to hold somebody at fault for just simply doing something and that the collision occurred. They have to be tied to one another. So they're super helpful. But generally, the law kind of establishes what a reasonable person would do. And that's what negligence is, right? Is were you reasonable? And so if you violate a standard, well, that's not reasonable, and therefore you're negligent, right? So that your actions aren't reasonable if you're violating those standards. And so that's kind of the idea behind negligence per se. And so that's how you can use it. Now, the speeding, if you're speeding, if you're running a red light, you're running a stop sign, those are things that, can definitely cause a collision. And if you violate those statutes, then you are acting unreasonable. And if a collision results, then you should be held responsible.
Thank you, Hank. You had some really good, concise answers to some of those questions. We have covered how fault gets investigated here in Harris County, the police report, the insurance investigation, physical evidence, and traffic violations. Now let's get into what happens when fault is not clear-cut. Because in a lot of Houston accidents, both drivers share some responsibility, and under Texas's modified comparative negligence system with the 51% bar, that changes everything about what you can recover. So both drivers point the finger at each other, and the insurance company for each side backs their own driver. What happens when both drivers claim the other person caused the accident?
So when that happens, generally I would recommend, getting a lawyer, and then the lawyer will help make the determination. And in most of the cases that I'm involved in that litigation is filed on, there's a dispute as to who's at fault or what percentage of fault people should have. By way of example, I have a case where a 18-wheeler ran a stop sign, and so you would think that they would admit that they were at fault and that they caused the collision. But the problem is that my client hit the kind of the middle of the 18-wheeler's trailer. And so the other side wants to argue that somehow my client was at fault for failing to take evasive action. Or I think they were going 3 miles over the speed limit. So somehow they're at fault for going 3 miles over the speed limit. And so insurance companies and defendants can say whatever they want, right? And the question is it believable, right? Will the jury believe it? And so as you go through litigation, a lawyer is paid to argue, obviously, and defendants will come up with arguments. And so my job as a lawyer is to present the evidence to a jury to help them understand why the other side is at fault and why my client bears little to no responsibility for the collision.
Under Texas law, both drivers can be partially at fault and the compensation gets adjusted. But there is a hard cutoff that can eliminate your recovery entirely. So how does Texas's modified comparative negligence work when both drivers share some responsibility for the crash?
Sure. So in the state of Texas, proportionate responsibility, the way it works is if you're more than 51% at fault for a collision, then you get no recovery. If you're 50% responsible, then you only get 50% of the amount of the damages awarded in the case. And so that's the way it works in Texas.
So the 51% threshold is a cliff edge. 1 percentage point can mean the difference between a significant recovery and zero. That leads us into the next stage. Once liability starts becoming clearer, both sides begin thinking about resolution, and that means settlement negotiations. So once the fault picture takes shape, the conversation shifts from who caused the accident to how much the case is worth. Once liability becomes clearer, how do settlement negotiations usually begin in car accident cases in Harris County?
Well, so settlement negotiations can occur really at any time. Oftentimes, I will tell clients that, when the insurance company is calling you wanting to settle real quickly right after a collision, it means that they know that they're at fault and they're trying to get a discount. So the insurance will call you up and say, oh, well, we'll give you $2,500 and agree to pay your medical bills to date. Well, that's not really a good deal, because if your damages are much more significant, well, then you're obviously shortchanging yourself a tremendous amount. And so one of the things you have to do as a lawyer is try to figure out what your damage model is and how valuable the case is. And then you can enter into negotiations. And so evaluating a damage model, you have to look at what do you think the jury is going to give you. And so the jury can give you money for past medical bills, future medical bills, past lost wages, future lost wages, past pain and suffering, future pain and suffering, past mental anguish, and future mental anguish. These are all the elements of damages in the state of Texas that you can recover money for. And so you have to analyze what do you think those are worth before you start negotiations. Then once you have an idea of what you think the jury would do with your case, then you can start negotiating from a reasonable standpoint to think this is what the case is worth.
So the demand letter is essentially the injured person's opening argument put in writing and sent to the insurance company. What is the purpose of a demand letter in personal injury settlement negotiations?
So the demand letter kind of outlines your case, right? This is what I think about liability, and this is what I think about damages, and here's the amount of money that I would be willing to accept to resolve any and all claims associated with this collision. And so it's a starting point, right? We call it kind of the ceiling that you create for yourself once you send it. I mean, it's hard to go up in settlement negotiations, right? Generally, when you start with a number, you're going to go down and the other side's going to come up, and you're going to meet in the middle somewhere.
The demand letter puts a number on the case, but how does an attorney arrive at that number? How do lawyers determine the starting value of a car accident settlement during negotiations?
Sure. So when you're trying to figure out what a case is worth, you've got to look at what does the law allow you to recover first, right? So what are the elements of damages that you're entitled to? And then you have to analyze the facts of your case as it relates to each element of damages, meaning let's take medical bills, for instance. You get to recover past medical bills associated with the collision or treatment associated with your injuries that you sustained as a result of the collision. And so as a plaintiff's lawyer, what I'm looking at is, okay, what all treatment have you had? And does it relate? Let's say somebody has back problems, but then, a few weeks after a collision, they have a heart attack. Well, was the heart attack related to the collision or not, right? Should those damages be included or not? Same thing about future medical treatment. Oftentimes as a lawyer, I'll get what's called a life care planner. That's a doctor that looks at all the medical evidence to say, okay, this is what this person's going to need over the course of their life as a result of these injuries. So it helps give the jury an idea of, hey, this is the type of significant treatment that this person's going to need as a result of the injuries. Because that's the key, right? The key is the medical treatment necessary as a result of the injuries you sustained? And that's whether or not it relates. And so you kind of put those numbers together, and then you start thinking about pain and suffering and mental anguish in the past and in the future. And, looking at other jury verdicts and kind of how juries value things, the nature of the injury. Is it a burn injury? Is it some other type of injury where, it's significant in nature? I mean, there's collisions that we're involved in where people become quadriplegics or paraplegics. I mean, that's a significant non-economic damages case. And so we want to look at all of those things to determine that. And then you can arrive at a figure that you think is reasonable based on the other side's ability to pay, because that's also a key consideration in all of this. Is there are cases that I've been involved in that the damages are astronomical, but if the other side doesn't have the ability to pay, well, then it doesn't really matter, because all you're going to get is a piece of paper. And so that's another thing that we have to talk to clients about all the time is, it's not only what are your damages, but what is the other side's ability to compensate you for those damages, right? So you have to look at that as well.
Thank you for explaining all of that so well. So negotiations can be where cases are won or lost. What strategies do personal injury attorneys use to negotiate higher settlements?
The way in which we feel you get the best result for your client is to approach each case as though you're going to trial. The reality is that most cases don't go to trial. Most cases get resolved at some point. But if you get your case ready as though you were going to trial, it sends the message to the other side that you're prepared and that you are expecting full and fair value for your case. some lawyers who don't prepare that way and just expect the insurance company to settle are not going to be able to maximize the value of a case because the insurance company knows that they don't want to go to trial. The big question is for the insurance company is how inexpensively can I get out of this? And if they feel like they can get out of it inexpensively or for less money, they obviously will. And so you want to make sure that you send the message that, hey, I'm happy to settle, but it's only going to be for fair value.
In some cases, settle in weeks, others drag on for years and end up in front of a jury. What factors usually determine whether a car accident claim settles quickly or moves towards litigation?
So the time associated with a case depends largely upon a number of factors. One, the nature of the injury. Two, the lawyers involved in the case. Are they realistic about what they're dealing with? Or is it some novel issue? And then three is just the amount of money involved, right? I mean, generally, if you're talking about a case that involves a great deal of money, there's going to be a lot more fighting associated with it because one side doesn't want to pay a great deal of money and the other side is going to want a great deal of money. And so those cases typically take longer. Also, it depends on the court. The courts that will set cases for trial and hold people's feet to the fire. In those courts, you generally get your cases resolved quicker because both sides are forced to make decisions about the case or go to a jury because the jury is going to be the final decision maker on that case, right? They're going to decide what the damages are. And so the best way to force people to be reasonable is to say, well, you're about to lose your ability to make a decision on settlement. So either you decide what you think the case is worth or a jury's going to decide for you.
All right, we have covered how settlement negotiations work, the demand letter, case evaluation, negotiation strategies, and the factors that determine whether a case settles or fights. Now let's talk about something that can end a case before it ever goes to court. Deadlines. In Texas, you have 2 years under Texas Civil Practice and Remedies Code Section 16003. So getting into Section 4, filing a lawsuit is a significant escalation, so attorneys make that decision carefully. At what point do lawyers typically decide that filing a lawsuit is necessary?
When deciding whether or not to file a lawsuit, we generally look at the type of case it is. The more significant the case, the more likely it is that litigation will be required. What you don't want to do is wait around to make that decision. So as a lawyer, we'll generally make that decision within the first few weeks of signing up a case. Should we go to litigation or do we not? Can we try to do a pre-suit settlement? Oftentimes in the cases that we're involved in, most of them go to litigation. In commercial cases, you should generally go to litigation because you have the ability to conduct discovery, send subpoenas, take depositions, and force the other side to give you information. And so in those types of cases where you need information in order to prove your case, litigation is a better route than pre-suit settlement discussions because you can't force someone to do it. It's all voluntary. And so that's why we always encourage people that, in a significant case, you're much better off to file a lawsuit early.
That is really important and informative. So every accident victim then in Houston needs to understand this next deadline. What exactly is the statute of limitations for car accident lawsuits in Texas?
So for negligence cases in the state of Texas, you have 2 years from the date of the incident to file suit. If you don't, then your claims can be time barred. There are some exceptions to that rule, but they're very few. So if you're a minor or you lack capacity and for some reason, then the deadline can be told, but generally it's 2 years from the date of the collision. And what that is a time bar. It means it's an affirmative defense. And what that means is the defendant, if you can still sue them 3 years later, but the defendant will come back and say, wait a second, you failed to file a lawsuit within 2 years, and therefore your case should be dismissed based on the statute of limitations. And then the court will then dismiss your case. And so it's a very important deadline that you do not wait. And so oftentimes what I hear from clients is they'll call me like a day after the statute is run or a few weeks after the statute is run, where the insurance company says to them, oh, well, we're going to settle with you, but there's no signed settlement agreement. And then they just string them along. And then once that statute runs, the insurance agent won't call them back. Or finally, we'll drop the hammer and say, hey, by the way, your 2 years is run, so we're not going to give you anything. And so, people are trying to do the right thing, trying to just handle it on their own with the insurance company. And what the insurance company is doing is they're strategically stringing you along so that they can completely deny you compensation altogether. And so it's a horrible idea to wait. And I encourage people to contact a lawyer quickly to figure out what they should do.
Yeah, that's awful. And a lot of people learn about the statute of limitations too late, sometimes after it has already expired. So, why is it important for accident victims to understand the statute of limitations early in the case? And I know you mentioned this just in the last question, but if you want to expand on it, maybe.
Sure. The statute of limitations is extremely important to understand for several reasons. One, it's going to prevent you from recovering anything, right? So you have to file a lawsuit within 2 years of your accident for negligence types of cases. And so you need to file that claim. There are certain types of cases, depending on who it is. I mean, if it's a governmental entity, there are shorter deadlines that you have to comply with. But these are all things that can completely bar your recovery. The other thing that's important about moving quickly is not just the statute of limitations, is that as a plaintiff, time is not your friend. I mean, the longer it takes for you to get a resolution, generally the worse it's going to be for you. And so whenever we take cases, we want to push them really, really hard because we know that the time is not your friend. The longer it takes, the more ridiculous arguments that the insurance company and the defense lawyers can come up with about why they shouldn't have to compensate. And so, that's why we always encourage people to make a decision early and to try to proceed as quickly as possible.
This is the worst case scenario, and it happens more often than people think. What happens legally if someone files a car accident lawsuit after the statute of limitations expires?
So if you file a lawsuit after the statute of limitations expires, what happens is the defense will file what's known as an affirmative defense. And the affirmative defense says that, hey, you filed your lawsuit after the statute of limitations, and therefore the case should be dismissed. And then they'll file a motion to dismiss the case. If you have gone past your statute of limitations and you haven't complied with the statute of limitations, then the court will dismiss your lawsuit and you will not have the ability to recover anything because you failed to file in a timely manner.
A lot of people assume that because they are actively negotiating with the insurance company, the legal deadline is somehow paused. How do ongoing settlement negotiations interact with the statute of limitations deadline?
They do not move that deadline at all. Insurance adjusters will tell you, oh, we'll get this worked out. Don't worry about it. We'll settle with you, and the settlement agreement's coming. And so then people, based on what they've been told, will wait. And then as soon as that statute runs, the insurance company is not going to pay you. They're going to tell you that it's too late, that you waited too long, and that they don't have any obligation to pay you. So you need to hire a lawyer. You need to file a lawsuit, and you need to move quickly because as soon as that statute runs, the obligation for them to do anything has ended.
A lawsuit has been filed at the Harris County District Court, and for most accident victims, this is unfamiliar territory. If negotiations fail and a lawsuit is filed, what are the first steps in the litigation process?
So generally, in the litigation process, a lawyer will file a lawsuit. Once the lawsuit's filed, then you have to get a process server to serve the lawsuit because then you have to give the person what's known as a citation with a copy of the lawsuit. And then they have the Monday following 20 days to hire a lawyer and answer the lawsuit. And then in the state of Texas, in state court, you have to wait 30 days. And then you can start doing written discovery. So you have to provide what are known as disclosures. And then once you provide those, then you have the opportunity to send written requests for information, both questions that the other side has to answer, but also requests for documentation and other evidence to help starting make your case.
Then, if negotiations have failed, mediation did not produce a result, and the case is going to trial, what happens if settlement negotiations fail and the case proceeds to trial?
Sure. So if you can't resolve a case, then you have to look at what is your next best alternative. I mean, we just tried a case a few weeks ago where it was an 18-wheeler driver who fell asleep at the wheel, and we couldn't agree on an amount of money that they should have to pay. And so we proceeded to trial, and we picked a jury and we tried the case, and the clients had to come to trial and testify, and we brought our experts in to testify. The defendants brought their company representatives and the driver in to testify, and the jury had to make a decision as to what they thought about the case. But the nice thing is jurors are just like you, right? I mean, they're everyday people who are trying to make the right decision, and so they understood the facts and the evidence, and they treated our client extremely fairly, and awarded us much more money than we were asking for in settlement negotiations. And so it's often not a bad thing to try a case, because then you have a number to work off of. The other side has a right to appeal, but you still have a number to work off of, and you know what the jury thought of your case.
All right, we have covered the entire arc of a car accident lawsuit in Houston and Harris County. What should accident victims in Houston think about fault investigations, negotiation strategies, and legal deadlines when planning their case?
When thinking about it, if you've been involved in a significant collision and you've suffered significant injuries, you should contact a lawyer. The best person to help you is a qualified personal injury lawyer who knows how to gather the evidence, knows how to present the evidence, and then knows how to use the civil justice system in order to get you maximum recovery for your injuries.
All right, for someone listening in Houston who has been in a car accident and is trying to figure out their next step, what is the one thing you want them to remember from this episode?
The most important thing to remember from this episode is that if you have been involved in a collision and you have questions, feel free to give us a call. We give a free consultation. We're happy to talk to you about your case. We're happy to let you know what we think. If we can help you, we'd love to help you. And if we can't, we're happy to give you some free advice as to what we think you should do, or give you a phone number of somebody else that might be in a position to help you.
All right, if you have been in a car accident in Houston or anywhere in Harris County and you are not sure where you stand with your claim, whether it is a question about fault, a deadline you are worried about, or a settlement offer that does not feel right, make that call. You can find Sutliff and Stout Injury and Accident Law Firm at www.sutliffstout.com or call them directly at 713-987-7111. Thank you for listening, and we will see you on the next episode of the Sutliff and Stout Legal Podcast.